Welcome, everybody. I'm Louis Lowe. I'm a partner at Foley Lardner in Silicon Valley, and I'm sitting here from my perch above University Avenue, and that's Stanford and the coastal range behind me. And I'm so honored today to have an illustrious group of partners of mine to talk to you about what's happening in the world. And our special guest, Christine Gorjanc, who's a director at Juniper Networks, among other of Silicon Valley's elite companies. And I welcome Christine today, and thank you for joining us. I'd love it if my partners could, and starting with Christine, could give us a quick introduction of themselves. Christine, let's start with you.
Sure. Good afternoon, everybody. My name is Christine Gorjanc. I am a former CFO of Netgear and Arlo Technologies. I'm on the board, as Louis mentioned, of Juniper Networks, Polestar, which is an EV company out of Sweden, and Forward Air Transportation out of Dallas, mainly serve on the audit committee.
Thank you, Christine. And Patrick, I'm going to move over to you next.
Patrick Daugherty, partner of Louis in Chicago. My focus today is on the SEC.
Thank you, Patrick. Ed, over to you.
Ed Burbach, Foley Lardner, Austin, Texas, chair of our state AG and FTC practice, and formerly head litigation for the state of Texas under then AG, now Governor Abbott.
Thank you, Ed. Jessie.
Jessie Lochmann. I am co-chair of the firm's Capital Markets and Public Company Advisory Practice, and we'll be spending time today with Pat talking about SEC developments.
Thank you, Jessie. And last but not least, Dr. Swift.
Christopher Swift, white-collar lawyer in Foley's Washington, D.C. and New York offices. I co-chair our international and national security team.
Wonderful. So I'm really honored to see so many old friends, and I look forward to making some new friends today. So thanks to everyone in the audience for joining us. We have a lot to get through in an hour, but really the genesis of this podcast today is the angst that we're all feeling about what's happening in Washington and in the states. And we thought we'd try and cover three areas today. And we're going to start with Patrick, Jessie, and Christine animating what's happening at the Securities and Exchange Commission and a little bit about what's happening with the antitrust authorities. We're then going to switch over to Ed and Christine to talk about the presidential executive orders. At last count, I'm up to 75, and the state reaction to those executive orders, both for and against. And then finally, we're going to end with Christopher and Christine talking about what's happening outside the United States and our relations with other countries, and really how all of this impacts our role as directors in some of the world's best technology, life sciences, and innovation companies here in Silicon Valley, with the goal of arming our audience members with new questions that they ought to be asking their management teams at their next board meeting. So kicking us off, I want to turn to my partners, Patrick and Jessie. And Pat, I'm going to start with you. And how do you think boards should be adjusting their governance practices in response to the new administration? And maybe we could even preface that by saying, what is the new administration at the SEC?
Oh, well, he hasn't been confirmed yet, hasn't even had his hearing, but Paul Atkins will be chairman.
Do we know Paul, Patrick?
Various partners of the firm have dealt with his company, Potomac. I've known him personally for 35 years.
But he's been a commissioner of the SEC before.
Yes,
so
he has.
He's a known quantity.
He is. He is a lawyer, a legal scholar, actually, and also a businessman.
And until he gets confirmed, who's in charge?
Mark Uyeda, acting chairman, whom I also know. Mark used to work for Paul when Paul was commissioner before. So did Hester Peirce, who's the third one. Some people call them a triumvirate.
So it should be pretty predictable what's happening at the SEC. So if you're a board member, how do you adjust your governance practices in response to what you know is coming down the pike?
Well, I pay close attention to any one of them, all of them. I would be reading the dissents that Hester and Mark wrote in their separate statements under the Gensler SEC and taking cues from that. I'd be reading law review articles that they've written. They also wrote some papers for the Trump administration in the lead up to the election, but Paul did anyway. I think my main point here is that we have a shift from regulation by enforcement to regulation by rulemaking and interpretation. And I think this is going to be an agency that asks questions of constituents before it writes rules and gives guidance to companies that want to do what's right. So I wouldn't worry as much going forward about what some people call mere technicalities, but I would remember the traditional concerns of the SEC. Atkins is very much a traditionalist, especially full disclosure of material facts.
Well, let me get into the nitty gritty, Jessie, because it's proxy season, and I know you're working on dozens of proxy statements. And back to the original question of, if you're a board member, how are you adjusting your governance practices? What's top of mind right now? And I'm thinking about shareholder proposals. I'm thinking about, am I in Delaware or am I moving to Texas? I'm thinking about what do I say, if anything, about climate? What do I say about sanctions? I don't want to steal your thunder here, Jessie, but you got a lot of material here.
A lot of material. So thanks, Louis and Pat. I think we'd start with, well, we'll run through a couple of topics here and keep going when you have a few more questions to come. But I'd start with ESG and climate related disclosure. That's definitely top of mind in terms of drafting of filings, a lot of 10Ks that were just filed, and proxy statements. You know, a lot of folks are saying they think ESG and the climate disclosure rules are dead. I think the climate disclosure rules that the SEC had promulgated are very likely and almost certainly, I think, Pat, you would say dead, but that doesn't mean ESG goes away completely. Businesses and companies who are involved in the EU still have the corporate sustainability reporting there. There may very well be institutional investors who still care about your climate disclosures and your goals. You have other constituents such as your own customers, your suppliers. So when I think about what should the board members be asking in this area, to me, it's a big overarching question of what's our corporate strategy around ESG, and how does ESG, if we're focusing on the climate piece of ESG, advance our long-term strategy shareholder value? It's not just about disclosure. I mean, we're focused on disclosure right now at this time of year for calendar year companies, but it's obviously more than that. It's how is this impacting the long-term value that we're creating, and do we have a strategy that makes sense? We started with what are the opportunities as a result of this new administration. I'd say this is an opportunity for boards to really refocus on climate issues, ESG generally, as a business imperative, not just a check the box exercise.
Christine, keeping it real, what's your perspective on all this?
I actually, I agree with Jessie, when I think of chaos versus opportunity, this is the one area that I see as an opportunity, both with less rulemaking. You won't have 5 new pronouncements coming down over the year and scrambling to figure out how to deal with it. We still have the international piece, which I agree. We have to deal with that and California and make it relate to the business. And I'd say that's as far as DEI when you're talking about DEI in the proxy, as well as ESG. And I think it's important. I mean, the interesting thing on Glass Lewis on your proxy, I think is ISS postponed weighing in on any of the DEI, and Glass Lewis, I heard a lady speak last week, still may weigh in on it because they have a lot of international customers and, as you mentioned, some institutions that still care. So I think it just has to be thoughtful, and it has to reflect who the company is, what their strategy is, and what their values are. They have to step back and really, believe what they're writing.
This is going to be a question for the group, because I don't want to put Christine on the spot. And folks, I'd be curious if you chimed in on the chat button, but have your organizations reaffirmed or rejected their commitment to DEI? And I'll start off by saying my law firm has recommitted to diversity, equity, inclusion as being a core value. but I'm hearing, especially from private equity-backed companies, that they are stripping out DEI from their corporate governance policies. Christine, is that something that you're hearing or seeing? And again, I don't want to put you on the spot on any specific company.
Now, I'm seeing that there's still a commitment to it, that we want to hire, we want to get the best talent we can get from with the right skill set from wherever we can get it, that they reflect our customers, our vendors and everything. How we talk about it might change, the acronym DEI might not show up there, but it's more of what are the values of the company, because we also have to, answer to the employees and the vendors and the customers. So I'm not seeing anyone walk away from it.
Jessie, there was this diversity rule that NASDAQ had proposed, maybe even adopted, and then pulled back. How should boards approach diversity and inclusion in this new environment?
And that's a very interesting question right in the heart of proxy season, because now that the Fifth Circuit has, shot down the NASDAQ diversity rule, the NASDAQ related companies, NASDAQ stock exchange listed companies no longer need to include that matrix in their proxy statements. But some of our clients are deciding to include it anyways, or modifying it for the reasons that Christina was just noting, which is depending on the strategy of that company and the constituents that they believe matter most to it, they may still want to disclose that information. I have other clients who are saying, we're going to go back to the diversity of thought, diversity of perspective, background type language, and focus on, the wide range of diversity outside of just gender and ethnic and racial diversity. Again, I come back to where I started with climate, which is this is the time for the boards, for the directors, not only on the nominating and governance committee relating to director nominations, but the overall board to be asking questions about what is our overall perspective on this? Who are the constituents that matter to us, that are helping us create long-term value? Our shareholders, our employee base, customers, suppliers, et cetera, and how should we be responding to this in light of what drives our business motivations? And that is a challenge given how fast and furious the new regulations and or new promulgations from Glass Lewis, ISS, different shareholders like BlackRock and Vanguard, they're all changing their views very rapidly in real time while we're in the middle of proxy season. So some companies are simply saying, we're going to stay with what we've always been doing and revisit this in the quiet time post-annual meeting. And I do think that's one practical way to look at this. Unless you're a business that's doing a lot of work with the federal government, in which you need to spend a little more time thinking about whether or not the current policies, procedures, your corporate governance guidelines, or otherwise are compliant with what the Trump administration's rules expect you to do in light of your federal government business.
I'm just translating for those of you not looking at the chat that folks are saying that most companies are still committed to DEI, but are focusing more on practice versus policy and are refining their language in the proxy around that. And that private equity backed companies are sharing my same experience, that they're discontinuing or at least going silent and dark on the topic. Jessie, because a lot of our audience here is in California, where there's some state rules about women on boards. How does that change the game if you're a company headquartered in California?
Well, my perspective is so long as those are still sort of the expectations or requirements, you need to be complying and explaining. And I think a lot of this is around explaining why you're doing what you're doing and why what you're doing is relevant to your business and to your company. I think that helps with the swinging pendulum of anti-ESG or DEI to make very explicit as to all of your stakeholders, particularly your investors who are reviewing your proxy statement or reviewing information on your website, why what you're doing is best for the company and your particular situation. So we can say going dark may be an option, but sometimes it's not. And sometimes what's best is to be very transparent as to this is why the company's strategy is what it is, but that does require that the boards are involved with the development of and oversight of that strategy in real time.
This is a question for the group, and Pat, I love what you said about the new administration's preference for rulemaking over enforcement. And we certainly saw a lot of regulation by enforcement under the prior administration. But how can boards ensure compliance without the fear of these regulatory gotchas impacting their strategic decision making?
Well, a couple thoughts there. One is to focus on the key concerns of the SEC. And I mentioned disclosure. The core of that is materiality. I would, if I were a director, I would want to have a conversation with my CFO and general counsel about how they view materiality, how they define it. The answer should be an economic measure or something about the economic impact of an event on our company relative to various financial statement items. This new SEC cares about economic materiality. It does not believe in double materiality or a material impact on the world, hence the fate of the climate change rule. Quantitative materiality is what matters. The other thing is that this SEC is open for business. I mean, one of the commissioners just last week issued a public statement asking 40 questions for public input on one topic alone. So if you have a question or matter that concerns you as a director, you should be asking your legal counsel to consider engaging with the SEC about it. I mean, call them up. They're taking meetings. Yeah.
What do you think the three top priorities are going to be for the new SEC under Commissioner Atkins' leadership, if you had to guess? And I know one of them you're going to say.
Well, sure. And much of this audience might not care, but digital assets is a top concern. I mean, there were many promises made by Trump to the crypto industry, and he has been fulfilling them. In fact, his appointments of senior executives in his administration evidence that, including Atkins. There's a lot going on there.
I think that requires legislation, but before there's regulation. But
yeah, well,
give me two more.
Well, I think another one is the climate change rules. Frankly, I think that stirred up an awful lot of debate. There's an appeal pending in the Eighth Circuit. I think that's probably going to be withdrawn.
So the climate rules go bye-bye. What's another priority, do you think?
Third one. I would say the third one is just the traditional concern about the integrity of financial disclosures. I would say, look, if this is financial fraud is not a gotcha. It's not a technicality. And, if I'm a director, I want to drill down on the financial statements and other financial disclosures. Every time I get them from management, I want to keep my eyes on those and ask lots of questions about them.
And I'll chime in with one more, if you guys
Please.
It's just yesterday at the end of the day, I'd say capital formation, because at the end of the day yesterday, the SEC released its expansion of opportunities for companies to submit confidential registration statements. And at a high level, that means the SEC is looking to make it more attractive for companies to file registration statements, either have follow-on offerings or IPOs, or consider getting back into the SPAC market. We'll see how that goes. But the idea is to make it easier for companies to try and raise money, because we've had such a lull in IPOs, and last year there really weren't any SPACs, and maybe they're dead, maybe they're not. But the idea is we need to continue to generate opportunities for companies to be able to participate in the capital formation process. And confidential filings really allows companies to do that with less risk that they're going to be exposed for what they're, intending to do, and have that create their business strategy while, folks wonder and worry about whether or not they're going to become public or not.
Well, to both of you, Patrick and Jessie, I'm going to switch chairs on you. I'm supposed to be the moderator, but I'm going to throw back at you that if you have any chance to talk to the SEC, I'd love to see them try and reinvigorate the capital markets, and especially the IPO market. I think it's too easy to be a decacorn private company that doesn't even publish any financial statements. Why would you ever go public? It's so expensive. And exposes you to such a wide range of exposure both to the management teams, but also to the boards and the many advisors. The cost of capital is massive. The global research settlement makes it impossible to get a wide following of research. I think decimalization of trading has made it unprofitable unless you're to do business in an IPO until it's a mega large company. I think that the overregulation and is also a big problem for public companies. So I think making it a little harder for these decacorns to stay private, and then making it a lot easier for companies to go public and remain public would be a huge help. But switching gears for a second, I want to move away from the SEC and talk a little bit about the antitrust authorities, because from here in Silicon Valley, it was real hard to get M&A transactions done in the last 4 or 5 years. And I think there had been some expectation that that was going to get a lot easier under the new administration. And we saw that President Trump appointed somebody who was well known to be pro M&A at the Federal Trade Commission, and Andrew Ferguson, whose only political statement seems to be about free speech. But then on the flip side, he appointed Gail Slater at the Department of Justice to run antitrust enforcement. And from what we've seen so far, she's decided to pursue the war against Google that the Biden administration began, and 2, very unexpectedly, she filed suit in the Northern District to block a merger between HPE and Juniper Networks that we all thought was sailing through. Christine, I don't know if there's something you could say about what's happening over there. You're obviously on the board of Juniper Networks.
Yeah, I would just say that the facts are out there, just like you said. They brought suit after the Trump administration came in office, and we move forward from there with HPE and Juniper, obviously separate companies, and go until the trial. So
we're expecting a full litigation of that matter in San Jose.
I believe that's what's out there, what's stated in there. It's in the Northern District, and I believe it's San Jose.
So on the one hand, we saw Tempur-Pedic and Sealy's merger getting approved, and we've got the concentration of mattresses. But on the flip side, a software company can't buy a networking company. I'm confused, but I digress. Switching topics, again, I want to move over to the 75 executive orders that have come down since January 20th. And I think we're, what are we, in week 6? So what is that average? 1 a day, Ed? How do you think about these executive orders? And as I look at them, I see a whole bucket of social orders about DEI, about immigration, about abortion, about the death penalty. I see economic orders about tariffs and sanctions, and maybe the government deficit and some sort of efficiency. And then I see all of these I don't know, geopolitical types of orders, whether it's, tariffs against our allies, tariffs against our enemies, renaming of oceans, taking over canals and continents. How do you look at all of these executive orders, Ed?
Yeah, I think for our people within our government solutions practice group throughout the firm, we look at them in different tranches. And I know Dr. Swift will cover those. Certainly, I think you gave a very good overview of the different ones. We've created a presidential transition hub to address the announcement of each of these executive orders, and through our website to give guidance to our clients and prospective clients about how to handle them. Obviously, a lot of this is driven by politics. I think it's been used the phrase shock and awe, and that frankly is how the new administration has approached these executive orders. Certainly with the goal of remaking government, and certainly with the goal of, in their mind, reducing regulation and restrictions on business activities within the United States, while at the same time being very aggressive in these social issues that we've talked about a little bit before about ESG, DEI, et cetera. So it is literally something we have to monitor on a daily basis. You may have seen the announcements which I know Dr. Swift will speak of, dealing with tariffs coming out today. So the bottom line is, for directors, I think the questions they need to ask their management is, in what operations are we taking forth in our businesses, and also how have these executive orders been issued, and are they seriously being carried forth, or is it mostly just a press release?
So that's a great point, Ed, and just one observation in helping our technology clients and innovation clients get business done. One of the things we're running up against is the person who we're dealing with in the federal government. Are they going to be there tomorrow?
Yeah, and it's been a big headache. We've seen a lot of people being appointed. I'm based in Texas. A lot of people being appointed out of Texas, Florida, elsewhere, coming out of state AG offices and related organizations. Obviously, Pam Bondi is now Attorney General of the United States, former AG of Florida. What we've seen is some of the leaders of the agencies have been appointed, have been instructed that they would not be able to choose their deputies and associate deputies, that the administration itself would put those people in place. So that is still going on to this day. We've got some colleagues who are involved in the transition for the Trump administration, and have been involved in choosing some of the people who are getting these important positions within the government. Obviously, you've seen in the last week or two some little bit of infighting, some would say, within the people that have been appointed to date, and some of that is probably the likely result of the shock and awe, the very quick movement with perhaps less than traditional organization coordination amongst the agencies. That's going to cause some disjointment over the next several weeks until it gets flushed out.
And Ed, do we think that the bulk of these presidential orders are behind us, or are we expecting a few to come?
We're expecting more to come. Obviously, we've seen quite a few, obviously. But we see it perhaps slowing down a bit, but certainly they're still coming and still being drafted.
One question for you all in the chat, Patrick and Jessie, do you feel like the Department of Government Efficiency is impacting operations at the SEC right now? You're on mute, Patrick.
Not yet, but it's about to. I mean, they are canceling leases for regional office in 2 cities. I'm in Chicago. They would cancel this one too, except that the penalties for doing that are pretty high. They're also offering. I'm getting phone calls from. They're also offering essentially buyouts for long-serving SEC employees for early retirement or quits. That was just yesterday that was offered. So
one of the pronouncements, and this is a one for everyone, is this Trump administration strangely suspended enforcement of the Foreign Corrupt Practices Act. Right. And somebody pointed this out in the chat, and looking for advice on how companies should adjust their compliance programs in light of this suspension. And Christopher is raising his hand. Please take the mute button off, Christopher, and come inside and tell us what you think.
Yeah, 3 things to keep in mind there. First, it's less likely to be an enforcement risk in the near term, at least while the administration is in power. Second, remember that the statute of limitations for the Foreign Corrupt Practices Act is longer than the 4 years the Trump administration will be in office. So unless there's a continuation of that policy after President Trump leaves office, or unless there's a constitutional amendment that allows him to stay in office for a 3rd term, the statute of limitations still matters, and these issues could be prosecuted in the future. And the 3rd and more important issue is for those of you who are doing business in other countries, right? Every country in the world except North Korea prohibits bribing officials in one fashion or another. And some countries, like the United Kingdom, also prohibit commercial bribery. So if you look at Canada, Mexico, the European Union, even China, under their Anti-Unfair Competition Act, which is sort of like FCPA meets antitrust all squished together, there's going to be a law that prohibits bribing an official. Also, it should note, state and local law prohibits a lot of bribery, kickbacks, et cetera. So just because the civil division at DOJ is taking a pause on the FCPA does not mean it's open season on bribery and corruption.
Thank you, Christopher. Ed, back to our description of what's going on in Washington. So it sounds like the major executive orders are with us. Of course, no one can predict the future. and there'll always be more, especially in the area of tariffs. How are the states and states attorneys general responding to what's happening in Washington? Are we seeing a kind of a movement towards to align with the federal government, or to push back and go against the federal government on these points?
Well, as you can imagine, it's a switch. Whereas back when I served as head of litigation in Texas, my former boss famously kept track of how many times he sued the federal administration, being a Republican attorney general. And then it switched, obviously, when we had to change administration during Trump 1, where the Democrats became very active. Flip-flopped again, now we're back. And certainly, if you just look at the press releases, and what's really changed is the attorneys general have become more and more politicized. Whereas I would say, going back 15 years ago, this is not scientific, it's a gut feel. About 80% of the AGs would have come from very serious legal backgrounds, very serious lawyers, and many times members of their state judiciary, many times members of their local state Supreme Court. To now, 80% of the AGs are former members of the House within their state or Senate, or former members of the House of Representatives in the United States government. And so the way they look at things has changed enormously. It used to be initially a look through a lens of a legal practitioner, whereas now their initial look is strictly as a politician.
Yeah.
And so whereas they would be driven by results in litigation before, they're now driven by putting out press releases. And so you see that in every state, and it's both parties. It's not just ours, it's not just D's, it's both of them. And so they become on steroids.
Yeah, here in California, our audience will know that State Attorney General Rob Banta is definitely a candidate for governor here, and sends me an email at least once a week. And I didn't sign up, I promise.
Well, they're all candidates for governor. So the acronym of the oldest bipartisan organization is NAG, the National Association of Attorneys General. The joke in the community is the National Association of Aspiring Governors.
Wow, and that sounds like NAG. So clearly states attorneys generals have become more politicized. What are the publicly stated and non-publicly stated priorities of these state AGs as you see it, Ed? And I know you follow both sides of the aisle on that.
Yeah, the easiest place to start is you can go to the two major partisan organizations, the Republican Attorneys General Association, RAGA, or the Democratic Attorneys General Association, DAGA. They actually have a website. They each have websites, and they list their priorities on those websites. So as in the past, where you would have seen as priorities working together on consumer protection issues, or perhaps similar sorts of concerns, and obviously years past, tobacco, opioids, et cetera. I just happened to visit the websites this morning to double check. And on the Republican AG website, it's protect the Constitution, uphold the rule of law, keep America safe. We are America's last line of defense. And also put out efforts on what they would see as anti-ESG, what they would see as anti-DEI, and also movements against the tech industry, those doing business in China, and healthcare. Whereas you go on the Democratic Attorney General's website, they actually have up today that they provide political and policy support to Democratic state AGs to protect citizens, promote progress, and support civil rights. And they list as their issues climate action, consumer protection, equity for all, healthcare, housing, LGBTQI plus equality, voter rights, worker protection. The bottom line is the AGs now believe they have jurisdiction over literally everything. Where if you would have asked me 15 years ago, it was mostly consumer protection, Medicaid fraud, and antitrust. Now it's literally everything. And it's outside their own jurisdiction too.
Well, Ed, for good or for bad, I'd say the hottest issue in Silicon Valley right now in relation to the states is, do I move my state of incorporation from Delaware to some other place? And you know, we've seen some pretty significant litigation between stockholders against some pretty famous and iconic Silicon Valley companies relating to compensation and other matters, which led to some pretty surprising outcomes. And I think Delaware is trying to address that with a new bill called SB 21, which I published a Substack on today. But Ed, what is Texas and Nevada and Florida doing to respond to what's happening in Delaware? And I know you're close to what's happening in Texas, so maybe focus on that.
Yeah, happy to do it. I'm based in Austin. I'm sitting here in Austin today. So as a little bit of a flavor, obviously we in Texas have been blessed with having the second largest population of any state and a gross state product of $2.96 trillion, a massive economy, second only to your state of California, obviously. The difference, though, in Texas is the debt difference. So in California, I think you're running at $500 billion worth of debt, whereas here in Texas, our government is running, we've got our last session, we had a $35 billion surplus. We now have a $24 billion surplus. So the question is, and we've won all these awards about for 20 years straight about being the most business-friendly state in the country. So the question is, how is it made more business-friendly? The answer is, number one, in our last session, there was a creation of a new court system in Texas, basically based on the chancery courts in Delaware with a Texas twist. So we now have Texas business courts that just came into effect September the 1st of this past September. And those are appointed judges. That's very unusual in Texas. Virtually every single one of our judges in Texas is elected by the people. That is no longer true. So we now have Texas business courts that have been created and funded in 5 major metropolitan areas in Texas. And on top of that, we've created a new Court of Appeals, but it has statewide jurisdiction. Intermediate court, the first one in our state's history. And those judges were initially appointed also by the governor. So in other words, the creation of these courts was one of the first steps to create what is seen as a more conservative court system that at least the leadership of the states will better serve the business community. So you no longer have to go in front of an elected judge in Dallas, Houston, Austin, San Antonio, who tend to be a little bit more liberal on business issues. Secondly, the governor has released a plan. I think his press release came out just yesterday to cut red tape for businesses, which, believe it or not, we in Texas even think there's too much red tape here. So becoming more and more business friendly, and also to get rid of a lot of more taxes. We don't have an income tax. There's now a big move to get rid of our property tax, and we're the beneficiary of enormous oil and gas reserves in our state. There's also an organization, for full disclosure, that our law firm represents, the Alliance for Corporate Excellence, which is a trade association, many different members of that trade association that are trying to support and codify the business judgment rule, which you've seen Nevada has already done. There's a move in a bill right now in front of our state legislature to codify that business judgment rule. Also to enable corporations to set an ownership threshold for derivative suits, to make it much less likely to have shareholder derivative suits, and to seek judicial certification of special committee independence before deploying capital, et cetera. So there's a lot of developments here in Texas to make it even more business friendly. And certainly the tax climate is very strong here.
Christine, over to you. Are you hearing or seeing, what's your reaction to this this phenomenon called Dexit, or get out of Delaware?
Unless I'm not hearing it much. What I hear more is if you're on a local, like a California company, or you're a, Tennessee company or something, you might want to move. But at this point, anyone's looking at sort of the pros and cons of moving, and what am I really going to get out of it? Am I happy where I'm at? And maybe not want to be a first mover to look at all of that and understand what it means. Unless you have just a really compelling reason to leave Delaware. So I'm not seeing it talked about as much, other than just understanding what's going on in the different jurisdictions, and kind of wait and see and watch what happens when some of the lawsuits come, and understand it when there's a little bit more information.
And Louis, could I add really quickly that we're seeing more and more state attorneys general take the position that if your company is headquartered in their state, they have nationwide jurisdiction. They'll say that if your company is located out in New York, but it affects somebody in Colorado, they can then bring claims dealing with that recipient of your business in California or in Colorado.
Wow. Well, stay tuned, folks. There's a bill in Delaware that would undo the litigation that Elon Musk was so unhappy about, and there's new legislation in Texas to codify the business judgment rule and to make it less easy to bring derivative actions, which I think are the two big objections that have been put forth so far to moving to Texas is, what are you going to get? Delaware, you've got this 100-year-old, very well interpreted statute. You've got this very, very sophisticated judiciary. What do you get in Texas? And the Texans are answering, and the folks in Delaware are answering. And so it's a scrum out there. And as companies look to make decisions about what they're going to put in front of their stockholders at their annual meeting and what they put in their proxy, I suspect that a lot of you out there are thinking about or considering these points. And thank you so much. And you all won't be surprised that we've saved, I won't say the best for last, but maybe the biggest topic is if you're going to be doing business of any kind, whether it's building something organically, buying another company, your own supply chain or the supply chain of the company that you're going to do business with, either in some sort of partnership or distributorship, or you're going to acquire them or be acquired. What in the heck is going on with tariffs, Christopher? How in the heck is it that we're taxing goods out of Canada and Mexico, our closest allies? Didn't we have a free trade agreement and 25% tariffs? What in the hell?
Well, you noted, Louis, that Ed said that the current administration is trying to remake government. And I think when you see the president speak at the State of the Union this evening, you will also see that he's trying to remake geopolitics and remake geoeconomics at the same time. And here's what I mean by that. Traditionally, we always had in the 20th century free movement of goods, free movement of capital, but not much movement of labor. In the 19th century, we had not much movement of capital, not much movement of goods, but relatively free movement of labor. And before that, we had most everything restricted and everybody was in their own empire. Well, what the administration's doing with their tariff policies, with their trade and investment policies, and with their immigration policies is to make the U.S. economy look more like it did in the late 19th and early 20th century. And we're seeing similar dynamics in terms of how they're approaching diplomacy and how they're approaching strategic affairs with NATO and elsewhere. And so what you see with Canada and Mexico is just the start. We will likely see in the coming weeks reciprocal tariffs on the European Union, followed by the potential for more tariffs on China, followed by potentially, depending on how the Trump-Modi relationship develops, the possibility of tariffs on India, which would be very complicated given the size of that economy and how diversified that economy's become. So bottom line is the free movement of goods, capital, and people across borders is over. We have shifted from globalization to regionalization over the first Trump administration and the Biden administration, and we are now shifting from regionalization to a much more nationalized economy that's consistent with the America First agenda. It's all out there for anybody who wants to read it. You may not agree with it, you may not believe in the economics, but they do have a plan, and they're implementing that plan pretty aggressively.
Well, Christine, I'm going to move it over to you to tell us what's really happening. I sit in maybe 500 hours of board meetings a year, and I sure as heck am not hearing about let's go do a transaction with the backdrop of the Dow having been at 42,000 up to 47,000, now back to 42,000, long-term interest rates up, inflation slightly up. And with all of these threats, what do you ask your management team to be ready for this?
Well, specifically on the tariffs, we've been down that road before. The first time, a lot of us moved our manufacturing plants. That is not an easy thing to do. That's a year to 2 years. And Vietnam was really quite easy. Got skilled labor. It was easy to get the raw materials there. We set up in Indonesia, much harder to get the same output that you get. So these are long-term decisions. I'd say right now we're asking the companies to quantify it, and what if it doubles? And do we have pricing power? Do we have domestic competitors that can just raise the price and make more money because the rest of us are going to have to? Do we have contracts that allow us to raise the price without renegotiating the contract? And then looking at our customers and seeing what other things are they they seeing and going through? So, I mean, I think this one is one of the bigger ones for most of the companies here in the Valley because we are mostly multinational and it affects everyone. And, a lot of people nearshored to Mexico, and now you've got that. So I think kind of looking at all of these issues, I think prioritizing kind of short term, middle term, and long term and scenario planning, because you don't want to change everything and then have the rug pulled out from under you later. So I think avoid any knee-jerk reactions. But it's definitely, people are talking about all of this in the board meeting. It's taking up a lot of time. European companies are sort of shaking their heads and trying to figure out what's going on. And so I just, it's a lot to it. And I think that, you have to decide what fits your strategic, what fits the company that you need to do. Because, bringing all your manufacturing back to the US is going to be really expensive and take a really long time, if ever, won't probably happen. So, what can you do to mitigate what's out there now? And then maybe long term, because they could turn around and go after tariffs on Vietnam and Indonesia and then moving would have been completely useless. And there's a lot of tax issues on this, just exit, tax, deduction, double taxation. I don't think people understand that. Make sure your tax departments are involved in anything you do, because you could completely upend whatever structure you have. I would just say it's sort of like supply chain came in during COVID, and now it's supply chain on steroids. Companies have to be resilient and do a lot of scenario planning at this point.
Wow.
That's
So much
exactly
to
right.
double click on that, Christine. So much to double click. Sorry, Christopher, you were going to say.
I was just going to say all the contingency planning that companies did during COVID to manage their supply chains, right? If you're the kind of company that designs something in one place but builds it in another, whether you have nearshored to Mexico or onshored from China to the United States, whether you've nearshored or if you've onshored, you're probably going to be in pretty good shape. If you nearshored or you just went to Southeast Asia, things are going to be uncomfortable. But every single thing that companies learned during COVID can be leveraged to help mitigate and manage supply chain risk currently. But COVID, I mean, Christine's 100% right here. COVID's the warm-up act for what is essentially Brexit times 1,000.
Wow, that's a little scary. So, Christopher, would you say that these tariff announcements are press releases, or are they long-term structural changes that are actually going to be implemented and stay there? Are we going to have 25% tariffs on Monday and then it's gone Tuesday and back Wednesday, or is this here to stay?
Yeah, so there's three categories of executive order, and Ed was citing to this or mentioned this earlier. There are the performative executive orders, which are designed to draw headlines, like changing the name of large bodies of water. There are the indicative executive orders, like the foreign investment executive order from a week and a half ago. Hasn't changed any rules yet, but it's designed to get everybody really worried about the CFIUS process and foreign direct investment, both in and out of the United States. And then there are the operative executive orders. And I'm sitting here looking at the actual regulations that were published yesterday in the Code of Federal Regulations implementing the 25% tariffs on Canada and Mexico. Right now, the president has, because the presidency is the International Emergency Economic Powers Act, which is essentially a national security law, to pass these. He doesn't have to go through the Administrative Procedures Act. He can drop these tariffs the way you drop sanctions on a terrorist syndicate or a narcotics syndicate. It's done just like that. And so he can turn these on and turn these off at his discretion. And that's the piece that's not entirely clear yet. We think this is part of a policy, but as boards start to push back and Wall Street starts to push back and people start to realize the second and third order consequences this is having, including on the stock markets, you might see some of this dialed back over time. I think it's more likely that what you'll see is picking of winners and losers, because the current administration's approach to industrial policy, in addition to jacking up tariffs and restricting certain types of investment and slowing immigration, is really been to figure out who the winners are and let them have exceptions, and figure out who the losers are and try to keep them out of the country. And that's part of the zero-sum global approach that this administration has brought. And it's part of what Ed was saying earlier. They're not just remaking government. They are trying to remake the economy and turn it into something more like what we saw between 1890 and 1927.
So, Christopher, I'm going to give you one last complex question and throw it open for the group, and then I think in the time remaining, I'd like to hit some Q&A in the chat box. And for those of you with questions, now's the time to go hit us. Those of us at NACD sit on the boards of public and private companies, and we sit on the boards of U.S. companies and non-U.S. companies. And a non-U.S. company might have a center of activity here in Silicon Valley, or they may pick board members here in Silicon Valley. And I know Christine, for example, sits on the board of Polestar, just to give an example. And both U.S. and non-U.S. companies are thinking about making investments in the United States and outside of the United States. And we've got these foreign investment rules that are in the U.S. and certainly the Europeans and the Chinese and the Canadians and the Mexicans are not sitting by idly. What's happening in the area of cross-border investment? And we've all heard about CFIUS, and then there's reverse CFIUS. And what should boards be wary of?
So there's two big trends. The first is the tendency to pick winners and losers and to use the CFIUS and reverse CFIUS process as a proxy for U.S. industrial policy. So I mean, we have 5 CFIUS cases going right now in my practice. We're going to add a 6th, maybe in another week or two. Some of these are very significant national security cases. Some of them are not. Even in the cases that are not significant from a national security perspective, we're seeing CFIUS ask the kinds of questions that you'd expect the DOJ Antitrust Division or the FTC or other domestic regulatory bodies to ask. So they're using national security authorities or securitizing the regulatory regimes of other agencies, again, to pick winners and losers. So that's one thing to be prepared for, right? If you're moving investment and capital across borders, really take the time. Make sure if you're sitting on a board that people are looking not just at the objective CFIUS rules, but at all of the subjective political and policy-driven factors that could get you investigated, even if you don't have a mandatory CFIUS filing. The other big change that's happening at CFIUS is 9 national security agencies backed by the 16 agencies that comprise the U.S. intelligence community. The Treasury Department is supposed to lead CFIUS. I know the Assistant Secretary of the Treasury who leads CFIUS right now at Treasury. I can tell you that the U.S. Department of Defense is creeping on their jurisdiction. And so there is a very strong desire within certain parts of the U.S. national security community, and especially at the White House, to make the U.S. Department of Defense the lead agency in the CFIUS process. And that means rather than looking at these issues in a way that balances security and economics, suddenly security is what's going to matter the most. I'm hearing the same thing from the Assistant Secretary of Homeland Security, who's responsible for CFIUS. And it's right there in Project 2025 and Agenda 47, if you want to read it. They're much more interested in securitizing these issues and thinking about it in a zero-sum framework, rather than looking at the kind of comprehensive framework that Christine was talking about earlier, where you're weighing business risks in addition to geopolitical conditions.
Well, I would reframe all of this from a Silicon Valley perspective as follows. There is an arms race right now to get to general artificial intelligence, or not generative AI, but sort of artificial general intelligence, AGI. And there are 2 ways of getting there. One is you've got to have compute power, that's GPUs, and that's NVIDIA and TSMC, where they're produced right now, and that's mostly in Taiwan. And next there's quantum computing, and that will be potentially when it has commercial use. And I'd like to hear your perspective on that, Christopher. Will radically change the outlook. And the way I'm seeing it now, countries are looking at artificial intelligence as a question of national security, and non-US companies that used to come to Silicon Valley to go get funded and to connect with customers are now being told by their local countries, hey, buddy, well, you got all the money you need right here. You need 100? Actually, you only need 10 cents, and here it is, and sit right down. Um, what should board directors be thinking of when they think about the war to get to AGI, the supply of chips and getting to quantum?
That is a really complicated question, Louis. We could do a whole seminar on just that. Let me highlight three issues. The first is we tend to talk about AI and use it as a brand. Some companies use it as a branding mechanism, but their AI may not be that interesting quite yet. So distinguish between the AI that is game changing and the AI that's convenient, right? Being able to ask Siri what restaurant to go to is not necessarily game changing AI, but the kind of AI you're talking about, Louis, that's a national security event. So when the 25 to 35-year-old staffers at CFIUS and the Defense Department and other agencies hear AI, they think this is a career development opportunity for them or perhaps a national security risk. Distinguish between the stuff that is convenient and the stuff that is game changing. Be sure your companies are doing that, because that collapsing those distinctions will attract scrutiny you don't want to have. The second piece is if you're doing quantum is NATO and friends, and probably English speaking NATO and friends. The DoD's approach to quantum, the US intelligence community's approach to quantum right now is highly restrictive. So, it's one thing if people are writing algorithms in a lab somewhere, but when they actually operationalize those algorithms, that's not the sort of place where, even if the law says it's okay to have the Chinese graduate student in the lab, the FBI is going to have a lot of questions for you that you don't want to answer. So think about who's working on those projects and whether your talent is going out the door at the same time, whether your tech's going out the door at the same time that you're attracting the kinds of questions and scrutiny from Uncle Sam that you don't want. And then the final thing here is, Louis, I'm kind of like you. I'm one of these people that believes that free markets and alliances and other things really matter. And so if I were working for a multinational corporation that was playing in either the AI or the quantum space, I would want to leverage my international relationships with allied countries to try to shape the battlefield from a regulatory and enforcement perspective in Washington, D.C., to focus on teaming up with our friends and containing our adversaries, and doing it in a way that maybe sounds America first, but is really perhaps, democratic governments first, and authoritarian governments second. And that's really important with AI, because the way you acculturate AI can have pretty significant consequences for how the AI is used in the political and economic and operational spaces.
Christopher, I think we've got our next topic just teed up for us, but I'm going to switch back to Christine as we get close to the top of the hour or the bottom of the hour, and ask Christine the obligatory AI question. As a director, in March of 2025, as we record this podcast, what do you think directors ought to be asking about management about their AI programs and their access to chips?
Mainly, what are we doing with it? What projects? Is it in our products? Is it just for internal, for customer service, for finance? Like you said, things that are just going to save time, or is it key to our products going forward, and distinguish kind of both the product structure and then the enterprise structure with that, and how we're doing, again, what are our competitors doing? What are we spending on it? Do we have the right resources? And I think talent is one thing in all these orders coming up on immigration. Are the visas that we have going to be, reconfirmed? Do we have the right talent? And a lot of us have R&D offshore and that. So I really think looking at your talent too. I think I just read that, so many people are hiring people with any knowledge on AI. So really understanding what the company's doing, again, sort of what their guardrails are, to make sure that we're not sending our information out into the public, but also what projects, the progress. I'm seeing it start to be reported more on a quarterly basis in what's going on the larger companies. I think some of the smaller ones are still grappling with it and trying to use it really just for efficiencies of scale.
Yeah, and I'll respond to that. I sit in, as I said, in hundreds of hours of board meetings a year, and so far in 2025, what I'm hearing a lot about are AI in two different areas. One is how are we using AI to drive efficiencies in our own operations? So that's irrespective of what our product is. It's how we're expensing things. And then two, for any kind of software company, is what is our AI strategy? And it's somewhat shocking to see many of these companies have none, and they're really fumbling around in the dark to discover, what that might be. And so those are two areas that if I was a director, I'd be asking questions about: is how are we using AI to reduce our costs, and then for our product, what is our strategy to use AI to make it a more compelling product to our customers? We've got so many questions in the chat, and I think we've tried to hit many of them, and many of them were left unanswered, and we'll try and follow up with folks. But I want to turn it back to my good friends Lisa Spivey and Kate Azuma to wrap us up. But before that, thank you to Christine Gorjanc and our my Foley partners for joining us today.